Welcome to literary and jury charge practice. Let's start out with this technical material. Get our fingers moving. Ready? Here we go. Most of us think of a magnet as a toy which picks up nails and other things made of iron or steel, but magnets are also used in many different ways to help mankind. One use of a magnet is in the compasses that are used to help navigate planes and ships. The first magnets were stones that were a type of iron ore. Nobody knew why these stones attracted metal. They were thought to be magic stones. Anything attracted by a magnet also becomes a magnet as long as it is in contact with the real magnet. Because of this, one could pick up several nails end to end. However, the magnetic field gets weaker as more nails are added farther away from the real magnet. When you take away the real magnet, the nails will fall. One could make a magnet by holding a short iron bar with one end pointing north and the other end pointing south. Place the north end to the ground in a slant and strike the south end with a hammer. The bar immediately becomes a magnet. The molecules have been jarred out of their random position and have arranged themselves along the magnetic lines of force. This is called a medical report. Let's give it a try. Ready? Here we go. Medical report of examination of Joan Kevin by Dr. Ralph Collins. A history was obtained from the mother, who is 30 years old and considered to be reliable. The mother stated that in February, while in the vicinity of Palatine, Illinois, the family was riding in their automobile and became involved in an automobile accident. She stated that at this time, Joan, age 11, suffered a cut above her left eye and was taken to a hospital in the vicinity of Palatine. She stated that she did not recall the name of the hospital. Approximately 3 sutures were placed in the cut at the hospital, and approximately 7 days later, Joan was seen by Dr. Warren Peterson of Rantoul, Illinois, who removed the sutures. The mother also stated that no x-rays were taken of Joan's skull and no x-rays were taken of any other member of the family who was involved in the accident. Since the accident, the mother stated the child has not complained of any headaches, dizziness, or inability to maintain her balance and has not complained of any difficulty with vision. She stated that Joan has seemed to maintain her normal average grades in school. The mother stated that she feels the child has permanent residual scarring from the accident, but stated that the child, other than this, has not been harmed in any other respect. The medical review is essentially non-revealing. The mother reports that the child had the usual childhood illnesses and without complications. There is no history of previous medical illness and no history of previous lacerations, and there is no history of any previous surgery. Essentially, there is no history of any traumatic injury, and the family history is non-revealing. The physical examination revealed a well-developed, slightly undernourished, asthenic, white female who appears to be her stated age of 11 years. On examination of the vital signs, blood pressure was 110/85 in the right arm, sitting position, pulse 96, regular, respiration 24 per minute, temperature 98.6 oral. Examination of the head revealed it to be symmetrical and with no irregularities noted. The hair was dark brown in color and the scalp was clean. No scars or tenderness were noted. We'll get back to this one. Let's try this jury charge. Ready? Here we go. Members of the jury, in this case, the state has charged the defendant, Bart Bell, with having conspired with a second man to commit the crime of kidnapping. The crime of conspiracy, as defined by the laws of this state, is committed if one person combines with someone else to commit a crime, and if either he or the other person does an act to carry out that crime. Before you may find Bart Bell guilty, the state must prove that all of those elements were present, and it must do so by evidence which is proven beyond a reasonable doubt. The first one requires that the defendant intended that the crime of kidnapping take place. The crime of kidnapping, as I use that term in this case, is committed by one who uses deceit to induce a child to go from one location to another, and who does so with intent to cause her to be secretly confined. This intent to cause her to be secretly confined must be determined to be fact. You cannot look into his mind to find out his intent. You may, however, determine if, from all the facts and evidence in this case, you may consider his conduct or any statements he made which show his state of mind. However, you should also remember that while you may find his intent from certain statements or conduct, you are not required to do so. You are the sole judges of the facts. The second element of the crime of conspiracy requires that Bart Bell did join in with somebody else to kidnap the child. He was part of a conspiracy if he went along with or agreed with someone else to do the crime. It is a mutual understanding that the two will work together for a common criminal purpose. The third element of this type of crime requires that one or both men did perform an act to effect the object of the conspiracy. Such an act must be more than mere planning. If there was any action which was a step toward accomplishing the criminal goal, that is sufficient. If you are sure beyond a reasonable doubt that Bart Bell intended to kidnap the child, that he was part of a conspiracy to commit that crime, and that one or more men did do something to contribute to the commission of it, you should find the defendant guilty of being a party to the crime. If you are not so satisfied, you must find him not guilty. As I said to you before, the offense of kidnapping, as that term applies to this case, is committed by one who uses deceit to induce a child to go from one location to another, and who does so with intent to cause her to be secretly confined. Before you may find the defendant guilty of this crime, you must be sure that the prosecution has proved the following three elements, and that it has done so by evidence which satisfies you beyond a reasonable doubt. First, that either Bart Bell or someone else induced the child to go from one place to another. Second, that Bart Bell or the other person used deceit to induce the child to go from one place to another. Third, that Bart Bell or the other person induced the child to go from one location to another with the intention that the child would be confined. Intent to cause the child to be secretly confined must be found as a fact before you can find the defendant guilty of being a party to this action. You cannot look into his mind to see the intent, but as I mentioned before, you may determine it from all the facts and evidence concerning this crime. You may consider his conduct or any statements he made to the police which may help define his state of mind. If you are satisfied that the prosecution has met its burden of proof, you should find the defendant guilty of being a party to the crime of kidnapping. If you are not truly satisfied, you must find the defendant not guilty. If you find Bart Bell guilty, you must answer one more question. Did Bart Bell commit this offense with the intent of demanding that the child's parents pay money in order to obtain the return of the child? Before you may answer this question, yes, the state must show you beyond a reasonable doubt that Bart Bell committed this offense with the intent to collect a ransom. This intent must be proven, if it is proven, from his acts and his words bearing on his intent. If you are satisfied beyond a reasonable doubt that the defendant did this crime with the intent to cause another person to pay money in order to obtain the release of the child, you should answer this question, yes. If you are not so sure, you must answer this question, no. As far as the witnesses are concerned, the general rule is that a person may testify only to facts that he or she knows. However, a person who has knowledge or education in a certain field may be allowed to give an opinion as an expert in that field. In deciding how much weight you will give to this opinion, you should decide if this person has the knowledge and if the opinion is based on established facts or agreed facts. I have allowed such evidence in this case to aid you in reaching a conclusion. If it does aid you, you must remember, however, that you are not bound by the opinions of the expert. During the trial, one of the attorneys instructed the expert to assume some facts, and he told the expert to assume that those facts were true. The attorney then asked the expert to give an opinion based just on those facts. This is what the law calls a hypothetical question. What we have here for some literary material. This is the text from a speed contest, a 220 word per minute literary speed contest. Ready? Here we go. In some cases, standard practice will have to be changed, but current seed stocks may be able to be relied on. We will need to keep records of what is successful and what is not, and to share the results with people and countries that were formerly competitors. Marketing successful methods and seeds that are reliable is currently big business. In order to feed our growing population and shrinking food supply, we are going to have to find a way to look past what is proprietary to what is essential. In some regions, we will be required to develop new crop strains. In other areas, we will need a combination of both new crop strains and changed practices. An important factor we also need to keep in mind is how flexible the farmers we need to rely on will be and how resistant they may be to changing older practices and habits. These essential changes will affect the economies of families, villages, and countries. They may require the purchase or modification of equipment and water delivery methods. Governments may need to share budgets in order to help farmers make changes quickly enough to save our food supply. What the study proposes is to survey all the affected regions of the world first. That includes those areas where we know the weather has already changed and will continue to do so. We will consider 4 things in these areas. The first consideration will be what the current crops are, which are in danger of permanent failure. The study will consider how resistant they are to failure under the coming conditions. The study will pull together this data to determine what can be done to improve yields in both the near and longer term futures. Along the way, the study will consider how flexible the farmers themselves are likely to be in the name of being practical. We also need to make some decisions about which regions we have the biggest impact on the most people worldwide. These 4 issues are going to need to get the first round of attention. This will likely mean that we go into more highly developed farming regions first, as these are the most likely to adopt meaningful change well. These areas also have the best systems in place to cope with extreme weather, which is also a concern. In these areas, the rate of change will likely be more organic as well. Poorer regions are likely to require more in the way of aid, as well as teaching to make the most effective use of changes and to apply the approaches to achieve the best results. Whatever we do, we need to begin sooner rather than later. We need to leave this meeting today with all of you giving us feedback as where to start, who to include. We ask you to share with us ideas or experience you may have in repairing and perhaps solving the crisis of global crop failure. Let's get back to our medical report. Ready? Examination of the head revealed it to be symmetrical and with no irregularities noted. The hair was dark brown in color and the scalp was clean. No scars or tenderness were noted. Examination of the eyes revealed the pupils to be round, regular, and equal in reaction to light and accommodation. The sclera and conjunctiva were clear, visual fields were full, and extraocular movements were normal. Ophthalmic examination revealed the disc to be normal in shape with no papilloderma noted. Normal arteriovenous ratio, no exudates or hemorrhages were noted. An area of scarring approximately 2 centimeters in length and approximately 2 millimeters in width were observed above the left eye and immediately inferior to the left eyebrow. This was very difficult to visualize with artificial light, and Joan had to be examined under sunlight so that the scarring could be approximated more accurately. Examination of the scars ears revealed them to be externally benign. The canals were clear and the tympanic membranes were clear bilaterally. Hearing was grossly normal. Examination of the nose did not reveal any external abnormalities. The mucosa was pink and no discharge was noted. Examination of the mouth revealed good hygiene and with no carious teeth noted. The throat revealed the palatal reflexes to be normal bilaterally. The uvula was in the midline and the tongue protruded in the midline. Some medical terminology there. All right, we'll get back to that. This is some legal literary is what we'll call it. Ready? Here we go. A corroboration you may consider that attributes of possession, time, manner, place. You may consider the defendant had an opportunity to commit the crime as charged, if that be a fact. You may consider the defendant's conduct and any other evidence which tends to connect the defendant with the crime charged. The flight of a person immediately after the commission of a crime or after he's accused of a crime is not sufficient in and of itself to establish guilt, but it is a fact which, if proved, may be considered by you in light of all the proved facts in deciding the question of his guilt or innocence. The weight to which such circumstance is entitled is a matter for the jury to determine. The burden is on the people to prove beyond a reasonable doubt that the defendant is the person who committed the crime with which he is charged. If, after considering the circumstances of the identification and any other evidence in the case, you have a reasonable doubt whether the defendant was the person who committed the crime, you must give the defendant the benefit of that doubt and find him not guilty. Eyewitness testimony has been received in this trial for the purpose of identifying the defendant as the perpetrator of the crime charged. In determining the weight to be given eyewitness identification testimony, you should consider the believability of the eyewitnesses as well as other factors which bear upon the accuracy of the witness's identification of the defendant, including but not limited to any of the following: the opportunity of the witness to observe the alleged criminal act and the perpetrator of the act, the stress, if any, to which the witness was subjected at the time of the observation, the witness's ability following the observation to provide a description of the perpetrator of the act, the extent to which the defendant either fits or does not fit the description of the perpetrator previously given by the witness, the cross-racial or ethnic nature of the identification, the witness's capacity to make an identification, the period of time between the alleged criminal act and the witness's identification, whether the witness had prior contact with the alleged perpetrator, the extent to which the witness is either certain or uncertain of the identification, whether the witness's identification is in fact a product of his or her own recollection, and any other evidence relating to the witness's ability to make an identification. The defendant is accused in the information of a burglary, a violation of Section 459 of the Penal Code. Every person who enters any building with the specific intent to steal, take, and carry away the personal property of another of any value, and with the further specific intent to deprive the owner permanently of such property, or who enters with the specific intent to commit a felony, is guilty of burglary in violation of Penal Code Section 459. A building is any structure. It is immaterial whether the intent with which the entry was made was thereafter carried out. In order to prove the crime of burglary, each of the following elements must be proved. 1. A person entered a building. 2. At the time of entry and the specific intent to steal and take away someone else's property, and intended to deprive the owner permanently of such property, or at the time of the entry such person had the specific intent to commit a felony. If you should find the defendant guilty of burglary, you must determine the degree thereof and state that degree in your verdict. There are 2 degrees of burglary. Burglary in the first degree. All other kinds of burglary are of the second degree. All right, that will conclude our literary and jury charge practice.